Good afternoon, everyone. I take immense pleasure on behalf of the KFCRI in welcoming you all for this brainstorming session on the topic of role of an arbitrator in an arbitral proceedings by our intern Madhumita, who is a third year law student, BA LLP student from School of Excellence Law. Over to you, Madhumita.
Good afternoon, everyone. My topic is on role of arbitrator in arbitral proceedings. We'll be covering on about who is an arbitrator, the qualities of an arbitrator, how is he appointed, finally about the role of an arbitrator. Before moving on to who is an arbitrator, let us see what an arbitration is. An arbitration is a form of alternative dispute resolution where the dispute between the parties is resolved by a neutral third party in an amicable manner. The parties mutually agree to submit their disputes, either existing or future, to arbitration. So it is clear that an arbitrator is a neutral third party who is appointed by the parties to resolve the dispute, and he is a disinterested third party. And the term arbitrator is derived from the Latin term arbitrary, which means to give judgment. An arbitrator is also known as the referee in an arbitration proceeding. Let us see the qualifications of an arbitrator. In order to be an arbitrator, a person must have attained the age of majority and must be of sound mind. Section 11 of the Arbitration and Conciliation Act also states that the arbitrator can be of any nationality. Then the eighth schedule of the Arbitration and Conciliation Act was introduced by the 2019 amendment. However, for the provision of the qualifications of arbitrator, however, it was omitted by the 2021 Amendment Act. So as of now, there is no hard and fast rule as to the qualifications of an arbitrator. Now, moving on to the qualities of an arbitrator. First and the foremost quality of an arbitrator is to be independent and impartial. Being independent is to have the ability to act without getting influenced by the parties or by the subject matter of the dispute in the arbitration. So, and also being impartial means having the ability to approach to a dispute with an open mind and without any prior decision about the dispute. And being independent and impartial will make the arbitrator to uphold the principles of natural justice, namely the nemo judex in propria causa sua, which means no person shall be a judge of his own cause, and audi altrum partem, namely let the other side be heard, and also the recent decision. So, Section 12, Clause 1 of the Arbitration and Conciliation Act 1996 provides that the parties must, the arbitrator, the person who is to be appointed as an arbitrator, must disclose his past and present relationship with the parties and also his interest in the subject matter of the dispute. Later, then coming to say fifth schedule of the Act, it states certain circumstances under which there will be justifiable doubts may arise as to the independence and impartiality of the arbitrator. In MS Voestalpine Shannon GmbH versus Delhi Metro Rail Corporation Limited, it was held by the Honorable Supreme Court that the independence of an arbitrator can be ascertained before the beginning of the arbitral proceedings itself. It will be identified based on the circumstances disclosed by the arbitrator. However, the lack of impartiality can be identified only after the beginning of the arbitral proceedings. Then moving on to the next quality of an arbitrator, he must treat the parties equally. So equal treatment of parties is to be maintained by the arbitrator. Section 18 of the Act clearly states that the arbitrator must treat each of the party equally and must give full and equal opportunities to them. Treating the parties equally can be ensured by providing equal opportunity to represent their case and also evaluating the evidence impartially and without giving weightage to one party's evidence over the other. So treating the parties equally will ensure the ability of the arbitrator to be impartial. Then So the next quality, he must maintain confidentiality. The arbitrator under section 42A of the Act is obliged to keep all the arbitral proceedings confidential. So the reason to maintain confidentiality is to maintain the privacy of the parties, to maintain the reputation of the parties, to preserve the evidence, and also to protect the trade secrets, and also certain secrecy of the parties, and also to uphold the integrity of the arbitration proceedings. However, it is to be noted that the arbitral award may be disclosed if it is necessary for its enforcement. Then coming to the appointment of an arbitrator, the section 12 of the Arbitration and Conciliation Act deals with the appointment of an arbitrator. So it says that the parties are free to agree on a procedure for appointing the arbitrator, and the party can appoint any number of arbitrators, but the number of arbitrators in an arbitral tribunal must not be equal. So if the parties are to appoint a sole arbitrator, they can do so. But in Perkins Eastman Architects DPC and another versus HSCC India Limited, it was held that in an arbitration agreement providing for adjudication by a sole arbitrator, the appointment of the sole arbitrator cannot be made unilaterally by one of the parties, even if the clause so vested such a power in the said party, because this judgment was given in order to maintain absolute fairness and impartiality in arbitration. So, if the parties are to appoint an arbitration tribunal consisting of 3 arbitrators, then the parties have to appoint 1 arbitrator each, and the so appointed 2 arbitrators will be appointing the 3rd arbitrator, and this 3rd arbitrator will be acting as the presiding arbitrator. Next, moving on to the role of an arbitrator. An arbitrator, similar to that of the court, has the power to provide interim measures. So he can provide interim measures for the appointment of a guardian of a minor, for a minor, or a person with unsound mind for the arbitral proceedings. And he can also provide for an interim measure of protection. So the interim measure of protection includes preservation, interim custody, or sale of any good which is the subject matter of the dispute or of arbitration. And he must provide interim measure of protection for securing the amount in dispute, and for the detention, prevention, or inspection of any property or thing, interim injunction or appointment of receiver, and also he can provide such other interim measures which he feels to be just and convenient. Then coming to the role of an arbitrator with regard to evidence. As we know, Indian Evidence Act 1872 does not apply to the arbitration. However, section 19, subsection 4 of the Act states that the arbitrator has the power to determine the admissibility, relevance, materiality, and weight of an evidence, any evidence. So he must evaluate the credibility and reliability of the evidence, and has to make the decision based on the evidence in his hand, and also based on the arguments presented by the parties, and based on the merits of the arbitration arguments, he must decide the case. So section 27 of the Act allows an arbitrator to apply to the court for assistance in taking evidence. Such assistance can be claimed to take any evidence, any documentary evidence or statement from any third party who is not related to the case, or any expert witness. Now, the next rule is with regard to proceed ex parte. So ex parte, the term ex parte refers to a proceeding where one party will participate without the other party being present or given prior notice. So section 25 subsection clause E of the Act states that if a party fails to appear to a hearing, or fails to produce any evidence, documentary evidence, then without any sufficient reason, then the arbitrator has the power to proceed ex parte, and he can also make the award based on the evidence before him. However, it is to be noted that an application can be made to the court for setting aside such an award made during the ex parte proceeding. Then, with regard to expert report, the arbitrator can also appoint an expert to report on certain issues specified by him under Section 26 of the Act. So, with regard to expert report, the parties must give relevant information to the to the expert for its inspection, and also if the parties or the arbitrator feels it necessary, the expert shall participate in an oral hearing. Then, if the party requests to do so, the expert shall make available for examination of all the documents, goods, or other property in his possession, with the help of which he prepared the report. Next, finally, with regard to the award-making process, the arbitrator has a very big responsibility to provide a fair and just and also an impartial arbitral award. So Section 29A of the Act speaks about the time limit for making an award. The time limit for making an award in India is 12 months from the date of completion of the pleadings. However, the parties may agree to extend the time limit for a further period of 6 months. If the award is not made within the time limit so given, then the mandate of the arbitrator shall terminate. And unless the court has extended the time limit and an application made by the parties, then definitely the mandate of the arbitrator will be terminating. Then let us see a general process of making an award. So first, initially, the arbitrator will analyze the facts of the dispute. Then he will take any evidence which is relevant to the dispute and the subject matter of the dispute. And he will hear the arguments of both the sides and will take the merits of the argument and will apply the relevant clause. And finally, will provide a fair and just arbitral award to resolve the dispute. And coming to the end, let us summarize what we have seen so far. We have seen that the arbitrator must be independent and impartial, and he must treat the parties equally, and also he must maintain confidentiality of he must keep the arbitral proceedings confidential, and he can provide interim measures which for the power of which is similar to that of a court, and he can take evidence. He can proceed ex parte, and he can also appoint an expert to report on certain issues specified by him. And also, he has the biggest responsibility, as I said before, to make an award. That's it. Thank you.
Thank you, Mamita. Your presentation was incredibly engaging and informative, and I appreciate the way you explained the complex ideas and clear concises. And your webinar has provided me with the wealth of valuable knowledge. I look forward to putting these insights into the practice and continuing to learn in the future. And thank you.